These are your top 10 tips for talking with the other side of a collection lawsuit. So if you're being sued by a creditor or a debt buyer, debt collector, you're going to have this instinct, this urge to get on the phone and call. This is similar to the advice I give people on my deposition videos. It's never a good idea to tell your story, since there's no benefit to it. You think there is because that's in normal conversations where people get to listen to your side and then you hear their side, which is going out of fashion in this country, unfortunately. Anyway, so take that along with you when you get that lawsuit. So I'm going to give you 10 tips on how to talk with the other side. And the title of this is Don't Talk to the Other Side. But if you must, I'm going to try and help you out. Again, this video, we're back to doing 2 a week now after the hurricane and holiday last week. I was in a bunker last week. Today I'm in a similar place. I'm still working on getting my place up to ship shape. The number one reason you should not talk to an attorney on the other side of a collection lawsuit is you got to remember the attorney is the ultimate PCer. He or she is always covering their ass. They really can't commit to anything. Long before there was wokeness or PC, political correctness, the attorney was out there making sure they're not committed to anything. They don't identify themselves as being committed for anything for their client, while at the same time insisting that you give them all the information they're asking for. So they don't make a move unless they have to. And it's usually in response or a reaction. They're sort of like the police in that they wait for stuff to happen and then they react because it's safer for them. An attorney is always covering their ass. There you go. At least that's been my experience. They will not consent to anything, and they will seek consent of their client on everything. So at the same time, they'll be asking you a lot of questions, and sometimes answers to those questions are a client's feeling that it's a price of admission to get to the ultimate place where you can debate with the attorney. So remember what I've just said there. We want to get to a certain point where we can get our case out and have the guy say, hey, you know what? You're right. We're going to just let this case go. It's said no one ever. It's not going to happen. But you think answering and agreeing to things with the attorney is, again, your ticket, your admission price to getting to where you want to be. The attorney on the other side of a collection lawsuit is just going to use that against you. Their belief is that you did something wrong or you owe something, and it starts there. So remember also tip number two, you're talking with the agent of the plaintiff that's suing you. But that goes both ways. They also are speaking for their client. So if you do get them to admit anything, you just got Discover to admit something or the debt buyer to admit something. It's, you're talking, don't forget, this is the rule of agency. You're talking with the actual person through an agent. And that client, person, plaintiff, company that's suing you has given the attorney authority. That's a heavy burden on attorneys. They know that. They don't want to admit to anything. Remember what we said in number one. So if you can pin them down to something, God bless you. In my experience, this should be number one, but in my experience, please don't forget this. The whole goal of a collection attorney, collection law firm, or a collection lawsuit is number one, get you to default. They have no interest in communicating with you unless it suits their attorney or the client's purpose. What does that mean? You have a statutory amount of time to answer the lawsuit. And if you're like me in the old days where, I had the black cloud of debt over my head, so I know everything out there, and you stick your head in the ground like an ostrich, hoping things will go away. You wait a couple of days inside that let's say it's 20 or 21 days to answer the complaint. And before you know it, 10 days have passed, and now you're working up the gusto to talk to these people, and it's getting worse. So by the time you talk to the attorney, nobody answers the phone. I know of at least one huge debt collection law firm here that fiddles with their phone system. So, and if you've had this experience, you'll know that's true. And then somehow, even when they take messages or voicemail, they don't come back to you. Why? My belief is to get that period where you have to answer the complaint over so they can immediately rush into getting a default. Defaults are annuities to both the plaintiff, the bank, or the debt buyer, and the attorney. They're the gift that keeps on giving. The attorney makes a lot more money on defaults, post-defaults, because the interest rates, and it's really hard after a default to really pin down a law firm as to how much you owe. I hear it all the time. Clients complain, I've paid more than the actual judgment, and they're still saying X, Y, Z. Here's the reason why a default is so delicious to a collection attorney. A default, by definition, is a judgment. And when a judgment occurs, the court doesn't want this case on their docket. When a judgment occurs, the collection law firm knows the case is done, they don't have to prove anything. When the judgment occurs, it's the gift that just keeps on giving. So there is in my belief, number 3, the tip why you've got to not make this a smooth ride for the other side. Get that lawsuit answered, because defaults are a Christmas, Hanukkah, birthday, Easter, name your great time, here's a gift just because I love you reason. It's the gift that keeps on giving. It's beautiful. It's a money tree for a collection firm. So number 1, don't let it happen. Don't even talk do not even talk to the other side until your answer is filed. Again, push down that desire or belief that you can just work this out, because you are in the arena of the attorney, maybe for the first time, maybe for the second time, but they are going to outclass you and beat you. And again, they will get admissions from you with the hope that now we can talk. Don't do it. Don't make it a smooth ride for the other side. You're wrong if you're making it a smooth ride for the other side. And admitting anything and not answering the lawsuit is the worst thing you can do. If by chance, unfortunately, you get a default judgment and you're facing garnishments, I have a video. Go to my video on getting out of defaults and garnishments. It's very useful. Never ever admit anything. Go back to number 1, sort of 2 and 3. Answering the questions so you satisfy the fox. Just remember, you're a plump chicken. Go into these conversations, I'm a plump chicken, this is a hungry fox. Now, what do you think the hungry fox is going to do? Hey, let me help you. Don't worry about me. You just tell me what happened. Wrong answer. Here's a tip. Everything is being recorded. No matter what you say, it's being recorded. If you want the information for those recordings to hear what was said, and you're like, oh God, I hope I didn't say, you'll never see it. The tape machine will break or something. It will take discovery if the thing even exists. But you are being recorded no matter what you do or say in this case. So never call if you must. Number 4 says, remember, every call is recorded. What's so important about what you say and what's recorded? Because frankly, the attorney, and if it's not an attorney, sometimes, I'm going to say 60%, let's say, of the people you talk to on a collection lawsuit are headset Harry. Well, who's headset Harry? He sits there he or she with a headset Harriet, with a headset with a script. Get the debtor to admit everything. Get the debtor to say that, oops, they're sorry. Is there a settlement possibility? Make them a a kind of a BS settlement, so then, oh, I can't afford that. Get them to admit things, but don't admit anything on your side. So when the attorney gets a hold of that, it may be the first time he's looking at the file, is the record, is the tape recording, is the data file. Attorneys operate on data files because they have, the collection attorneys have so many cases they can't, like, for example, you give me a name of a client, and I'll tell you what's going on with the case. I don't have thousands of cases. I got a lot, but I know every case. The collection attorney may be operating of hundreds to several hundreds of cases. That's probably not the way to operate, but these days, fewer people, more cases everywhere. So that's how they operate, from the data file. So if you said something wrong and the guy, Headset Harriet, has written down an admission, that will be the theme of the collection attorney from there on. He's going to always remind you of that. And now you're operating already from a bad stance. So, just like in my how to take a deposition or how to protect a client from a deposition, never tell a story. For some reason you've called and not listened to my first 4 tips. Number 5 tip is telling you, don't offer an excuse. Collection attorney, I'm hesitating because collection attorneys don't do the best work. It's not a place where successful people go working for others. They want to, and that's maybe the successful in saying, you know what, I don't need the stress of my life. Being a collection attorney, I get there at 9, I get out at 5, I do some court. There's a lot of success to that if your goal is not to do perhaps anything creative, just to go along, pick up a paycheck. That's no different than General Motors, and that's a good place to work. Security, it's all about security. Well, there's a lot of collection lawsuits, and there's going to be. So I'm not putting a person's choice of how they feed themselves, pay their bills, or help their family. But along with being a collection attorney, is you're not going to do a lot of good work because there's thousands of cases. Here's the secret. The attorney is signing off on that lawsuit. You really think that he's signing thousands of lawsuits a day? You make your own call on that. They file thousands of pleadings because that's how a debt buyer, debt collector, a creditor makes money. The margins are getting thinner and thinner. So everything is ChatGPT. If ChatGPT did everything, the human involvement would be little, the margins would increase. Hey, wait a minute, that is what's happening. Lawyers are getting nailed all the time for using ChatGPT. If you want to use that, and there's nothing wrong with that, check the work just like you would check an associate or somebody else doing the work for you. But back to the tip number 5, stop offering excuses. You give your story. When you give your story, give them your wallet at the same time because it's the same thing. Number 6 says, treat this like it's number 6, but here's number 6. Treat it like a criminal case. There's actually a part of FDCPA called the mini Miranda rule, and it has to do with what is said. In the mini Miranda rule, a collection attorney, every time, a collection agency, every time, anybody collecting debt must say, we are debt collectors. Anything you say for that purpose will be used against you, essentially. Doesn't that sound kind of familiar to something? Yes. The Miranda rule, not the mini Miranda rule, which is civil and debt collection, but the Miranda rule says you have a right not to have to say anything and have it not be held against you. You have a right to an attorney. It's much deeper than that. But it works the same purpose. You can only hurt yourself by talking. See number 5. So treat it like a criminal case and shut the hell up. The attorney's unlikely to call you. Headset Harriet maybe as a collection attempt, but it's never a good reason to give your story. Now I'm going to tell you something in number 7 people are going to yell at me. A collection attorney, especially when they work for creditor lawsuits, has their number one priority. I'll give you 5 seconds to guess. No? You're not helping me. Well, the number one priority is making sure their clients' needs are taken care of and they get the best. That's not their number one priority. The collection law attorney's number one priority is protecting his ass, is protecting the client account. Yes, they're going to try to collect the client, but this is my opinion. They're going to try to protect the client. Of course they're going to within the rules. But in my opinion, from 30 years of doing this, their biggest fear is losing an account. You can take advantage of that. Not necessarily losing the case, which goes a long way, but the attorney is going to justify his existence, justify what he's doing, first and foremost, when he communicates with his client. He's going to maybe treat his client the same way he's going to treat you. He's not going to commit to anything. The client is going to trust he or she to make the best decision for them. So this is strictly my opinion again. I have seen and continue to see a large disconnect between the attorney fighting for truth and the attorney and his client, and the attorney fighting for themselves. That's my opinion. What do I do with that information? I make it so that the attorney, who is really through the human condition of self-preservation first, because that's really what's generating what I see, as opposed to client first, then attorney's needs. It's just a very large human condition, and this again is my opinion. I have acted in that regard where I've pressured the attorney such that they will then go pressure the client. If you can get that turnaround, they're no longer operating for the client. Why are they doing that? A number of reasons. These lawsuits are pumped out by Head Said Harriet. She's writing the thing. The attorney, it's supposed to have signed it, and the attorney may not see that lawsuit for the first time until you filed an answer and maybe filed your own motion, or you're questioning the complaint, which is a good thing to question because it usually sucks, because they pump out hundreds of thousands of these. There's going to be errors. There's going to be named wrongs. There's going to be statute of limitation excuses. I know for a fact that with creditor accounts, meaning JP Morgan, Citibank, American Express, whoever it is, they're tougher on their attorneys because they haven't sold the debt off. They own that debt now, and they want their money. And there's always pressure on the collection attorney for creditor clients from above. I know it. I've got attorneys and creditors coming after me because they see I'm upsetting the apple cart in a certain way that is going to ruin the attorney's case for this client. I know for a fact in some cases, one particular case actually, where the case against me is all or nothing. They keep saying it's against me even though it's Smith versus whomever the creditor client is. Everything is about Mr. Parker, Mr. Parker, Mr. Why? Because they fear that if I get my way, they will lose the client. I know, I've heard that. I got like 4 attorneys in different law firms in one case. It's only a $10,000 debt. So that's what happened. So don't forget that. What is my point? The attorney isn't always, hopefully, my number one belief is that the attorney is looking out for their client's goals first. If you can take anything away from that, that's my belief. Have I seen differences where that's not necessarily the case? Absolutely. Debt buyers perhaps could care less. They tell the attorney, $1,000's owed, go get what you can get, we pay pennies on the dollar. Creditor clients are more serious. So the creditor client is going to give the attorney for the creditor client a harder time. This is about the whole law firm losing a big case. I'm telling you all this because you must know that before going into battle. You're going to get a different response from a creditor attorney, and this is the point of number 7, than you will a debt buyer. A debt buyer attorney, if you owe $1,000, you could get it down to $100 if you do your right thing. But again, don't let that, what you perceive to be the right thing, is giving away the ranch. Because if those negotiations break down, now you're back to $1,000 again, and maybe you admitted something. So in both those cases, the collection attorney for the debt buyer and the collection attorney for the creditor, they're only going to get XYZ amount of money. If you answer the lawsuit, their ability to make money generally does not increase. So now they're getting a smaller piece of the pie. Usually when another law firm comes in, someone's granted them authority to make more money on a file, but generally they won't do that. So it's always a good reason to try to answer the lawsuit. Either hire someone like me or do the answer yourself. And again, I've talked about how one of the options out there is to use solo suit. I'm about to unleash something, maybe in my next video. Solo suit is they're committing a really critical error in telling people how to do these lawsuits without one major thing. They're not telling people to do it. You have to in Michigan. But if you answer the lawsuit yourself, you are killing their bottom line. You are protecting yourself. And the likelihood of anything you say in settlement negotiations will be protected by the court and the rules that protect you from having settlement negotiations. So keep in mind, anytime you settle a case or talk about settling a case, it is protected generally by the rules of evidence, because if we didn't have that window to settle, then we would flood the courts because no one would be able to settle for fear what they said would hurt them. Why does it hurt you then if you're protected? Because it will be used against you down the road. It will provide rocket fuel for the collection attorney if he's on the fence about whether you owe it or not. And it will be used in a way that's going to be not very nice, what I'm about to tell you. They, again, as I said previously, set up the system so that you will not answer. Number 8, you will not answer the lawsuit. So they'll engage with you in settlement discussions. Yeah, I'll get back to you Sunday, which let's say it's the 16th day and they're not calling on a Sunday. Now by the time you get back to you, it's the 20th day and you only have 21 days to answer. They'll have a settlement discussion and then boom, 21, they delay you. They default you. Seen it happen. You can go see exactly that discussion in my default and garnishment video. That's very helpful. But the attorney's goal at number 8, tip number 8, is hers or his goal. It's not to help you. So just like in my video, it's similar as far as negotiations. Don't give away your story and don't be sucked into this, hey, this guy's a nice guy, he's just trying to do his job. I'll help him out. If you are liking the person you're dealing with in a collection lawsuit situation, if the word collections in the reason why you're talking with this person and you're liking the person, that's a canary in the coal mine that you just screwed up. You are giving away the ranch. And even if you don't end up paying anything at that point, you're going to pay down the road. So it's never a good reason to talk with collection attorneys unless, if you have to, and you've looked at my tips, and you understand that sometimes attorneys are operating for themselves and not their clients, in my opinion, then you are always going to fail if you don't keep my tips in mind or the fact that you're dealing with a very hungry fox and you look like a very plump chicken. No offense to plump chickens. Don't agree to anything. Let your pleadings do the talking. You go to collectionstopper.com for a guide, for research. I'm not telling you how to operate or do your business either in Michigan or Florida where I operate or in any other state. This stuff is for help and research, just like anything else. I'm going to give you another really cool tip. Number 9, don't agree to anything, but remember they're taking notes and you're going to see those notes down the road. You're telling the judge you don't owe it and you said, well, I kind of owe it, but if I can get a good deal. Now those notes will come out accidentally or beyond settlement discussions, however, or there are exceptions to the rule that you can't talk about settlement discussions, and maybe they will claim they fit one of those to bring out the fact that you tried to settle. They're attorneys trying to win for themselves and their client. Take your own notes. How do you take notes? Even if they're just writings and you're not taping. You write the date, you write the time, you wrote who you spoke to, something key. A person kept coughing, or there was a scratching on the phone. Because if a recording does come out, it might be that that comes out and that will be credibility. But take notes, the day, the time it happens. Your time when this happened is exactly what you want to go down on the paper. You time, what was said, who was said it, where was said, what number you called, what number they called, did they call you, did you call them? Get it all down in writing and keep it in a book and date each page so that you can have credibility in those notes. It may help you in the end. So if they can take notes, you can take notes. What you can't do, which I would never recommend you do, although you are legally covered, is tape them. If, for example, you're in Florida, it's a state where you have to get permission of the other side. In Michigan, there's a case, I think it's called Sullivan, but I am not 100% sure about this, so I'm not going to give you advice as far as Michigan, but I believe you don't need the other side's permission to tape them. In Florida, you do. Literally, I've done this myself. I will go online and go, what states do I not need permission to tape somebody? And if you're solid on the reputation and credibility of whoever's giving you that information online vis-a-vis your jurisdiction, you might want to tape them. Tapes can help you. They're taping you. So anyway, the attorney, here's number 10, and one of the best tips. It's like a car dealership for many reasons. They're not on your side. Fox, plump chicken again. But also, you go and buy a car, not so much these days because you can research the heck out of it, but they go back to the general manager. Oh, general manager says you're closed, but we need X, Y, Z. It's just like buying a used car at a car dealership. Act accordingly. There's always more room and more offers to get. Don't feel grateful that you owe $10,000, they agree to $8,000 and $300 a month because you just want this off your head. It's a lot like getting a divorce. When you're going for a divorce, you just want it over so you can get out there and be free and do whatever. And then 2 years later, you're paying this check. And you're like, oh my God, why did I agree to this? Because at the time, freedom was what you wanted, and we won't talk about why. It's the same thing. You don't want to be 2 years from now making a $400 payment and you're like, whoa, don't agree to anything unless there's been good negotiations. If you must negotiate, which you shouldn't. Again, car dealerships. But make sure you get everything in writing. Don't accept the first offer. Here's a bonus round. If you ever hear someone say, I have to take this back to my client, whatever you say to them, that goes back to number 1. An attorney can't speak for the client, even though it says right under the caption, J.P. Morgan, attorney, blah, 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 blah. They really can't talk for the client. they have to keep covering their ass. See, number one. So don't be the reason why they say I have to go back to my client, and those other reasons I just gave you, is they want that 21 days or that 20 days to pass so then they can default you. Assume the worst when someone says, let me go back to my client. You will notice they're not offering you anything until you offer them something. And then they don't come back with helping you agreeing to it. Number 2 tip, bonus round. If someone asks you, well, you owe the debt, right? I can get you a better deal if you just tell them you owe the debt, and then we can just get right down to how much we can help you out. You're safe with us. They're trying to get you to admit something that you will see down the road. So if you hear tip number 2, hey, it's your debt, right? Hang up. Or say, hey, I have to hang up now unless you want to deal with me appropriately. Always ask, tip number 3, the attorney, can you do everything for this client? Do you have authority for JP Morgan, for Midland Credit Management? Always ask that. Because remember, you're being taped, and that alerts the attorney when anybody asks questions like that. Do you have authority to accept my offer today? So don't offer anything. Go, if I make you an offer today, do you have authority to accept? You will find out rather than 5 minutes later finding out that you gave all this information. So if you must call the other side before anything is said, say, do you have authority to accept my offer if I make it? If you see a wishy-washiness, then you must get away from that. If you hear yes, great. Make sure, if you're allowed, it's taped. Make sure you've written it down. If you must engage, and then make a low ball offer, because they may come back with lower than what you thought you could settle for this. Negotiation, quick tip on negotiation. You just have to establish your floor and their ceiling. And you want to settle around the dining room table or the chandelier, right in the middle. So find out what their ceiling is, as low as they'll come. Know your floor, as high as you'll go, and then the two shall meet. Or frankly, as low as you want to go. But you've got to get it in the middle somewhere. But don't engage anybody that isn't willing to say that they have authority. That's the number one thing. Any salesperson will tell you in any negotiation, if you're dealing with someone that doesn't have authority, what's the point? I have to go back to my wife and see if she's interested. Salesmen hate that. It's an objection that they should overcome, and they should have qualified their prospective buyer. So I want you to qualify who you're working with. Do you have authority to accept my settlement today? Sound like a salesperson, right? Settlement discussions are not allowed to be used to prove liability. Are they? Yeah, in the head of the attorney. Remember, the attorney's ultimate goal is to protect himself. Then he wants to protect his client. Those two aren't contradictory, and there's in no way that an attorney is protecting himself. Am I saying that there's a model of ethical responsibility violation? I'm telling you of the human condition, and that may be outside of operating as an attorney, but attorneys are covering their ass first, and it should be compatible with their client's needs too. I've just seen some weird things in my life, and if you get to the point, and I do, where you are worrying the attorney, and you should, about, oh my God, I'm going to lose this client, they'll turn it around and they'll negotiate for you. It happens. So I jokingly say, my name is Brian P. Parker. P stands for problem. I can tell you from day one, there are people that are so smart, can handle themselves, and can be a real problem in negotiations on any level. And if you can be using your innate intelligence, because you all got it, you just got to tap it, and be a problem for an attorney that just wants to be there from 9 and be there to 5. I don't have to think about this guy. Oh, this guy again. Oh, this guy. Because he has to engage you. The attorney, he or she has to engage you. It can't be written down that I'm not talking to that guy. Because now, again, they're going to look like they're not doing their job. So if you just start being a problem, you will succeed. And you don't have to admit anything, just be a problem. So now the guy, you answer the lawsuit and the guy, I don't want to deal with this guy, and they're not making any money. Be a problem maker, not a problem solver. And it will serve you well. But I think the best tip I can give you is, there's a great line in Seinfeld. You got to have hand. A situation where George Costanza's dating this girl and he's unemployed, he lives with his parents, and she's a microbiologist. He has no hand. Why is she going to go out with him? In a perfect world, she sees what a great personality and how sensible he is. Okay. You got to have hand. Your hand is the following. File an answer. File affirmative defenses. Because you can't be defaulted however long they want to delay you. And you know what? If you were to just engage them, the collection attorney, in settlement discussions before you file the answer, just do it in a safe amount of time. I'm not telling you to do this, but just for research. And then file the answer, and now talk settlement discussions. I guarantee you that thing will move really fast after you file. Because until you file an answer, they are looking at default. That's the collection attorney's #1 goal, is a judgment. The machine is set up to default you. The phone system at the collection attorney's place is miraculously not working when you call. Headset Harriet doesn't have the authority right now, but she can maybe do something. I'll call you back in 10 days. And I've heard clients, I got defaulted and I worked out a settlement offer with them. Until something is signed and the case is dismissed, assume that they're trying to screw you over again. Sorry, that's the way it is. Recognizing that #1 tip, answers and affirmative defenses will lower your amount you eventually have to pay if you, again, want to engage attorneys on your own. And the time you settle the case will be much shorter from when you file the answer to when you settle it than when you just keep talking to them and they keep delaying before you answer. The collection attorney operates on small margins. If they have to go to court, which they will, if you answer and file affirmative defenses on a relatively low amount, they know they now have got to go to pretrial. They've got to make arguments they don't want to. You put it right back on the attorneys who are always trying to cover their ass. They will suddenly have better authority from their client that they didn't have before. Take it any way you want. I'm just giving you 30 years of my dealing with collection attorneys. So, they're looking out for #1. You look out for you and yours. Don't admit anything. Get as much information as you can without giving. Please, I see it all the time. We think we will admit a couple of things, so now we can get to that place that we think we're taking the attorney who's just recording everything. And again, this is the case with dealing with the Headset Harriet too, at the collection law firm that finally answered your lawsuit. Answered the phone about the lawsuit. Keep an eye on that 20 or 21 days. They want to delay you. If they smell that they're close to the default point, they'll maybe get you completely settled without signing anything, then suddenly you're defaulted. That deal is gone. They'll blame you. You didn't make a payment. I've seen that. They'll blame you. You didn't sign or send anything over to them. They'll blame you. It's a system set up for your failure. The collection system is set up for your failure. How do you beat that? Check out collectionstopper.com. It's everything you need to create your answer and your jurisdiction's answer. I'm not telling you what to say or what to do, or I'm not telling you how to be an attorney in your jurisdiction. I'm saying, here's what I do. act accordingly, and only if it fits your needs, your facts, and your jurisdiction. My show notes is something that I always write for 99% of my videos. So if you don't want to look at this face again or go through this nonsense, the show notes are great tips to give you what you need, so you're not trying to find out where did Parker say this, where did Parker say this. So I put them on my website, collectionstopper.com. It'll be show notes for top 10 tips when you're dealing with an attorney or a collection attorney, something like that. It'll be easy, and you could take it along with you when you're working with the collection attorney or headset Harriet. But again, let's be clear on a couple of things. There's never a good reason to call or negotiate with a collection attorney, and if you must, do it after the answer is filed. I'm going to tell you my experience, but my opinion, I have seen attorneys negotiate from a place of self-preservation that may or may not be in line with their client. That's my opinion of my experiences, and I don't suspect anybody's breaking any rules. It's just some interesting stuff, and you see interesting stuff after 30 years. Number 3, take your own notes. Why can't you take notes? Why can't you tape? You don't know those people, and they certainly don't know you, and they have a very bad opinion of you because all debtors owe everything, even though there's ID theft. So you can take notes. Obviously, you can tape. Check out the jurisdiction. Make sure the person you are dealing with, salespeople already got this, and I'm just repeating something. Make sure the person you deal with has authority. It kind of sets them on their toes or on their heels, and they will be careful about what they talk to you, because again, attorneys are careful animals. They're protecting themselves, they're protecting their client, and they don't like you. Don't forget that. They do not like you. So if you hear someone being nice to you, head for the hills in this situation. It's horrible, just like in my deposition videos. It's not the time to be human, especially in this situation. They're coming for you, and they're gonna steal your money, and steal is a bad word, but they're gonna take your money unjustifiably if you say the wrong thing. I've seen cases where the client definitely didn't owe the debt, and they're paying. I gotta get them out of that judgment. Sometimes you can't. I don't want that for you. So I wanna help you. Check out my research, check out collectionstopper.com. And then rock and roll, man. Use these show notes. Again, you can always email me, say hello, ask for a class, ask for 10 minutes, comment and like. What else are you supposed to say? Oh, also subscribe and keep this thing going so I can help and help and help. Thank you very much for your time.